What if a man asked to be killed and another agreed to do it? What if every step was recorded, documented, and done with consent? This question sounds hypothetical. It sounds like a philosophical exercise, the kind debated in ethics classrooms or late-night discussions about free will. In 2001, it became a real case, with a real victim, a real perpetrator, and a legal system forced to draw a line it had never clearly defined before. In a small town in Germany, a man named Bernd Jürgen Brandes volunteered to die. He did not do so impulsively. According to court records, he searched for months, communicating online with strangers until he found someone willing to fulfill his request. That person was Armin Meiwes. Meiwes did not abduct Brandes. He did not deceive him. He did not deny what happened afterward. Everything was documented. Everything was deliberate. And everything was done with what both men described as consent. When the case became public, it stunned the world. Headlines focused on the most shocking elements, reducing the story to a single, grotesque label. But behind the sensational framing lay a far more consequential issue, one that continues to shape how modern legal systems understand consent, responsibility, and the limits of personal autonomy. Because the central question of this case was never whether Armin Meiwes committed the act. He admitted it. The question was whether consent could ever make such an act lawful. At the time, German law did not explicitly address a scenario like this. There was no precedent for a killing carried out with the active participation and approval of the person who died. Prosecutors, defense attorneys, and judges were forced into uncharted territory. Was this murder? Was it assisted suicide? Or was it something the law simply did not know how to name? The initial answer shocked many. Meiwes was first convicted of manslaughter, not murder, and sentenced to 8.5 years in prison. The reasoning centered on consent. If the victim had willingly participated, the court argued, then the moral weight of the crime was different. Public reaction was immediate and fierce. Legal scholars, victims' advocates, and ordinary citizens questioned whether any society could allow a person to consent to their own destruction at the hands of another. The case was appealed. The law was re-examined, and the original ruling was overturned. What followed was not just a harsher sentence, but a legal declaration. Consent, the court ruled, has limits. A person may choose many things. They may not choose to be killed, and they may not authorize another person to do it. This case became a turning point, not because of its extremity, but because it exposed a fundamental boundary. It forced the legal system to answer a question that modern societies often avoid. When does personal autonomy end, and when must the law intervene to protect life itself? This story is not about shock for its own sake. It is about why the law exists and what happens when human choice collides with irreversible harm. To understand the ruling that followed and why it still matters today, we have to examine how consent failed, why it failed, and why the law ultimately had to say no. Long before their names became permanently linked by a single, horrifying event, Armin Meiwes and Bernd Jürgen Brandes lived separate lives shaped by isolation, loss, and unmet psychological needs. Understanding who they were before they met is essential, not to excuse what followed, but to explain why consent in this case could never be considered equal, informed, or legally valid. Armin Meiwes was born on December 1, 1961 in Essen, Germany. His early life was defined by abandonment and control. His father left the family when Armin was still a child, disappearing entirely from his life. The absence left a vacuum that was filled almost exclusively by his mother, who exercised strict and pervasive control over her son. According to psychiatric evaluations presented at trial, Meiwes was raised in an environment that discouraged independence, emotional development, and social integration. He grew up largely isolated from peers, spending much of his childhood and adolescence alone. Court-appointed experts later testified that Meiwes developed intense fantasy worlds early in life, often as a coping mechanism for loneliness and emotional deprivation. These fantasies became increasingly elaborate over time, centering not on violence in the conventional sense, but on the idea of possession and permanent union. Meiwes described a desire not simply to dominate, but to absorb another human being, to make them part of himself in a literal and irreversible way. Despite these internal struggles, Meiwes functioned outwardly as an unremarkable adult. He completed his education, served in the military, and maintained steady employment in the information technology sector. To colleagues and neighbors, he appeared quiet, reserved, and socially withdrawn, but not overtly threatening. There was no documented history of violent crime. No known attempts to act on his fantasies in the physical world prior to 2001. Bernd Jürgen Brandes, by contrast, was born on April 9, 1958, into a family that, on the surface, appeared stable and affluent. He pursued higher education and became a successful computer engineer, holding a well-paying position at a major corporation. Professionally, he was respected. Financially, he was secure. But his internal life told a different story. Brandes's childhood was marked by trauma that would leave lasting psychological scars. His mother died by suicide when he was young, an event that psychiatric experts later described as profoundly destabilizing. Testimony and records presented during the trial indicated that Brandes struggled with chronic depression, deep-seated feelings of abandonment, and a persistent sense of emotional emptiness. He experienced difficulty forming close relationships and lived largely alone. Unlike Meiwes, whose fantasies revolved around possession, Brandes's inner world reflected self-erasure. Experts testified that Brandes exhibited signs of severe self-destructive ideation, expressed not through overt suicide attempts, but through a desire to disappear entirely. His communications later revealed a fixation on being consumed, both metaphorically and physically, as a means of ending his existence while giving it meaning. It is critical to note that Brandes was not legally diagnosed with a psychotic disorder at the time. He was able to work, manage finances, and navigate daily life. But legal capacity does not equate to psychological health. Court-appointed psychiatrists later testified that Brandes suffered from a paraphilic disorder combined with suicidal tendencies, impairing his ability to make decisions free from pathological compulsion. The Internet became the bridge between these two lives. In the late 1990s and early 2000s, online forums provided unprecedented access to communities built around extreme fantasies. These spaces did not create Meiwes or Brandes' psychological conditions, but they allowed those conditions to find validation, reinforcement, and eventually real-world expression. Meiwes posted messages seeking a willing participant for his fantasies. Brandes responded. Their communication was extensive and deliberate. According to court records, they exchanged messages over several months, discussing expectations, boundaries, and consent. To an outside observer, the level of planning might suggest agency and mutual agreement. To the court, it revealed something else entirely: the convergence of two incompatible psychological vulnerabilities. This imbalance is central to understanding why consent failed as a legal defense. Meiwes sought fulfillment through control and possession. Brandes sought annihilation. One stood to gain psychological satisfaction. The other stood to lose his life. These were not equal positions, nor were they the product of sound, autonomous decision-making on both sides. Psychiatric experts emphasized that Brandis's willingness to die did not arise from rational deliberation, but from long-standing mental distress. His consent was not an expression of freedom, but of desperation. In legal terms, it lacked the voluntariness required to excuse another person from responsibility for taking a life. Meiwes, for his part, was found to be fully aware that what he was doing would result in Brandis's death. He understood that the act was irreversible. He documented it. He preserved evidence. He later admitted to it without denial. The issue was never whether he knew the outcome. It was whether he was entitled to carry it out. The court ultimately concluded that he was not. The lives of Armin Meiwes and Bernd Brandis did not collide by chance. They intersected at the precise point where untreated psychological distress met opportunity. Their meeting exposed a dangerous misconception that consent alone can neutralize harm. In this case, consent did not protect the vulnerable. It facilitated their destruction. Understanding who these men were before the crime clarifies why the law intervened as it did. Consent assumes equality, capacity, and freedom from coercion. None of those conditions truly existed here. What appeared to be agreement was, in reality, the final convergence of two broken trajectories, one that the law could not, and ultimately would not, allow to define justice. The meeting between Armin Meiwes and Bernd Brandis did not occur in secrecy or haste. It was the result of months of communication conducted openly within online forums dedicated to extreme fantasies. According to court records, the internet did not introduce the men to violence. It introduced them to each other. That distinction became critical as investigators later attempted to determine where responsibility truly lay. In the late 1990s and early 2000s, online communities operated with minimal moderation. Forums allowed individuals to express fantasies that would have been socially unacceptable or even alarming in any offline setting. Within these spaces, statements were rarely challenged. Instead, they were normalized through repetition and mutual reinforcement. For individuals already struggling with psychological distress, this environment reduced internal resistance rather than increased it. Meiwes used these forums to post explicit requests seeking a willing participant. His language emphasized consent, preparation, and mutual agreement. Brandis responded. Their exchanges were detailed and prolonged. They discussed expectations and outcomes, including the certainty that Brandis would die. The presence of such planning later became a focal point in court. To the defense, it suggested agency. To the prosecution, it demonstrated premeditation. When the two men finally met at Meiwes' home in Rothenburg, the outcome followed the trajectory they had discussed. What is legally significant is not the sequence of actions themselves, but the framework within which they occurred. Meiwes documented the encounter. He did not conceal the evidence. He later cooperated with authorities. These facts complicated the initial legal analysis. There was no denial. There was no attempt to obscure intent. The question was how to classify an act that appeared voluntary on both sides, yet resulted in irreversible harm. The Internet's role became central during the investigation. Prosecutors examined whether the forums constituted encouragement or facilitation. Ultimately, the courts did not treat the online platforms as criminal actors. Instead, they recognized the Internet as an accelerant. It shortened the distance between fantasy and action. It allowed two vulnerable individuals to validate one another without external intervention. But it did not remove individual responsibility. The legal breaking point arrived when the case reached the courtroom. German criminal law, at the time, lacked a clear category for a killing carried out with consent. Assisted suicide was addressed separately and typically involved medical contexts. This case did not fit. Prosecutors initially charged Meiwes with manslaughter, arguing that Brandes' consent mitigated culpability. The trial court agreed. The initial verdict stunned the public. Meiwes was sentenced to 8.5 years in prison. The court reasoned that because Brandes had actively participated and requested the act, Meiwes' moral blameworthiness was reduced. Consent, while not fully exculpatory, was treated as a significant factor. This reasoning triggered immediate backlash. Legal scholars warned that such a ruling risked establishing a dangerous precedent. If consent could mitigate responsibility for killing, then the law would be forced to recognize a right to self-destruction facilitated by others. That concept conflicted with the foundational principle that human life holds intrinsic value beyond individual choice. The case was appealed. During the appellate proceedings, the focus shifted decisively. The higher court examined not only the facts, but the implications. It considered whether a legal system could permit a person to authorize another to end their life outside strictly regulated medical contexts. The answer was unequivocal. In its ruling, the court rejected consent as a valid defense. It held that an individual's willingness to die does not grant another person the right to kill. Consent, the court stated, ends where irreversible harm begins. The law exists not only to respect autonomy, but to protect fundamental interests that individuals cannot waive, including life itself. Psychiatric testimony played a key role in this reassessment. Experts testified that Brandes' mental state impaired his capacity to make a free and rational decision. His consent, therefore, could not be considered informed or voluntary in the legal sense. This finding reinforced the conclusion that the apparent agreement masked a profound imbalance. Meiwes was retried. This time, the court convicted him of murder and sentenced him to life imprisonment. The ruling marked a clear boundary. Regardless of documentation, recording, or mutual agreement, the act remained unlawful. The presence of consent did not reduce the offense. It underscored the need for legal intervention. The Internet, once again, featured prominently in public discussion. Some argued that online anonymity had enabled the crime. Others warned against overregulation that could suppress expression. The court avoided these extremes. It did not criminalize speech or platforms. Instead, it reaffirmed individual accountability while acknowledging the environment that facilitated escalation. This case established a legal principle that extends far beyond its circumstances. Consent cannot be used to legitimize acts that destroy life, even when harm is requested, even when it is planned, even when it is documented. The law draws its authority from the protection of values that cannot be surrendered, regardless of individual desire. The breaking point, therefore, was not technological. It was ethical. The court was forced to confront the limits of autonomy in a modern society where private decisions can have public consequences. It answered by reaffirming a line that many had assumed was self-evident, but had never been tested so directly. This ruling did not resolve every question raised by the case. It did not address how to intervene earlier when individuals express self-destructive intent online. It did not establish clear protocols for monitoring extreme communities. What it did was assert a baseline. When a choice results in death, the law must intervene, even if the choice was mutual. The act itself was the endpoint. The Internet was the conduit. The law was the final barrier. When that barrier was tested, it held. When the appellate court revisited the case of Armin Meiwes, it was not merely correcting a sentence. It was clarifying a principle that modern legal systems often assume but rarely articulate. The question before the court was not whether the facts had changed. They had not. The question was whether the law had failed to protect a value it claimed to hold above all others. In overturning the initial manslaughter conviction, the court reframed the issue in definitive terms. Consent, it ruled, does not neutralize responsibility for killing. The presence of agreement, documentation, or even repeated affirmation by the victim does not transform an unlawful act into a lawful one. Life, the court asserted, is not a negotiable interest. This reasoning marked a critical shift. Rather than treating consent as a mitigating factor, the court treated it as legally irrelevant in cases involving intentional killing. The ruling emphasized that the state has an obligation to protect life not only from external threats, but from situations where individuals seek their own destruction through others. In doing so, the court rejected a purely individualistic interpretation of autonomy. Meiwes was sentenced to life imprisonment. The decision was widely reported as a correction of moral imbalance. Yet its significance extended beyond punishment. It established a precedent that continues to influence legal reasoning in cases involving assisted death, extreme bodily harm, and self-destructive agreements. Legal scholars noted that the ruling drew a firm boundary. Autonomy allows individuals to make choices about their bodies, their beliefs, and their lives. It does not allow them to delegate the act of killing to another person. Where that line is crossed, the law must intervene, regardless of consent. This distinction has direct relevance beyond Germany. In the United States, courts have consistently held that consent is not a defense to homicide. Even in jurisdictions that permit physician-assisted dying, the conditions are narrowly defined, medically supervised, and procedurally regulated. The Meiwes case illustrates why those safeguards exist. Without them, consent becomes an unstable foundation for irreversible harm. The case also reshaped how courts view vulnerability. Psychiatric testimony played a decisive role in affirming that Brande's consent was inseparable from his mental distress. The law does not require a finding of insanity to recognize impaired judgment. It requires recognition that certain choices emerge from conditions the law is designed to counter, not endorse. By affirming this, the court reinforced an important principle. Protecting autonomy does not mean abandoning individuals to their worst impulses. In some cases, intervention is not a violation of freedom, but its preservation. Public reaction to the final verdict reflected this understanding. While the details of the case continued to provoke discomfort, the legal outcome was broadly accepted as necessary. Few argued that the initial ruling should have stood. The discomfort shifted from outrage at punishment to unease at how close the system came to legitimizing a fatal agreement. The precedent established by this case continues to resonate in discussions about online communities, mental health, and the limits of free expression. While the court did not criminalize speech or fantasy, it affirmed that when ideas translate into irreversible harm, responsibility attaches to action, not intention alone. The case also exposed a gap in early intervention. Both men expressed extreme beliefs and desires online long before their meeting. Yet there was no mechanism to identify or address such risk without infringing on lawful expression. This tension remains unresolved. Modern societies continue to grapple with how to distinguish between speech that is disturbing and conduct that is dangerous. What the court resolved was narrower, but no less important. It drew a line at this point of death. Whatever uncertainties surround online influence or psychological diagnosis, the act of intentionally killing another person remains unlawful, consent notwithstanding. This clarity is the enduring legacy of the case. Not the shock of its facts, but the firmness of its conclusion. The law does not exist to ratify every choice individuals make. It exists to uphold boundaries that protect collective values, even when individual desires push against them. The verdict in the Meiwes case reaffirmed that some lines cannot be crossed, not because society is intolerant of difference, but because it recognizes the permanence of certain harms. Death is irreversible. Consent cannot reverse it. No agreement can undo it. Why does this still matter? Because modern life increasingly blurs the line between private desire and public consequence. Online spaces connect individuals in ways that bypass traditional safeguards. Ideologies, fantasies, and self-destructive impulses find validation at unprecedented speed. In such an environment, the principle affirmed in this case serves as a legal anchor. When confronted with choices that extinguish life, the law must say no. Not out of moral panic, but out of obligation. The Meiwes verdict stands as a reminder that autonomy has limits, and that those limits are drawn where harm becomes absolute. The case of Armin Meiwes is often remembered for its extremity, but its lasting importance lies elsewhere. It forced the legal system to confront a question most societies prefer to leave untested. Can a person give valid consent to their own destruction, and can another person lawfully carry it out? The court's answer was unambiguous. Consent ends where irreversible harm begins. No agreement, no matter how deliberate or documented, can authorize the taking of a human life. This principle is not rooted in moral outrage or cultural discomfort. It is rooted in the law's obligation to protect life as a value that transcends individual preference. What made this case uniquely difficult was not uncertainty about the facts. The facts were largely undisputed. What challenged the system was the appearance of choice. Brandis sought death. Meiwes agreed to provide it. On the surface, this resembled autonomy in its most radical form. The court rejected that framing. It recognized that autonomy does not exist in isolation from mental health, power imbalance, or the permanence of consequence. By imposing a life sentence, the court did more than punish an individual. It established a boundary. It affirmed that the law cannot abdicate responsibility simply because harm is requested. In doing so, it protected not only potential victims, but society itself from the normalization of irreversible self-destruction facilitated by others. This ruling continues to matter in a world where private desires increasingly find public expression. Online communities connect individuals with shared impulses, including those that are self-destructive. Technology accelerates contact, validation, and escalation. Yet none of these forces alter the legal reality affirmed in this case. When intent becomes action, and action results in death, consent does not shield responsibility. The Meiwes case also serves as a reminder of what the law can and cannot do. It cannot heal psychological suffering retroactively. It cannot intervene in every online exchange or private fantasy. What it can do is draw clear lines at points of absolute harm. It can refuse to legitimize agreements that extinguish life, even when those agreements appear mutual. This is not a rejection of compassion. It is an assertion of duty. A society that values life cannot outsource its protection to individual choice alone. The most vulnerable are often the least able to recognize when their choices are shaped by despair rather than freedom. In the end, this case is not about cannibalism, notoriety, or shock. It is about the limits of consent and the role of law in defining them. It demonstrates that some choices, even when freely expressed, cannot be honored without undermining the foundation of justice itself. The file closes here, not with ambiguity, but with clarity. The law exists to protect life, even when life is surrendered willingly. When that boundary is tested, the answer must remain firm. Consent does not excuse killing. It never has, and it cannot.